Seated. The third case for oral argument this morning is John and Karen KOENIG appellants versus Bonita London appellee. For the appellants, we have Mr. Andrew Fick, an attorney from Sioux Falls. And for the appellees, we have Mr. Aaron Fox and Mr. Richard Travis, attorneys also from Sioux Falls. I understand, Mr. Fox, you'll be presenting this morning?
That's correct, Your Honor.
Okay, very well. With that, then, Mr. Fick, you may proceed, sir, and you have 20 minutes.
Yes,
The court, counsel, my name is Andy Fick, and I'm an attorney with the Fuller Williamson Law Firm in Sioux Falls. We represent the plaintiffs in this case, John and Karen KOENIG, who are present here today. The KOENIGs respectfully request that this court reverse the trial court's summary judgment rulings in favor of defendant Bonnie London on the KOENIG's negligence and negligent supervision claims. The KOENIGs seek this relief for three reasons. First, the trial court erred as a matter of law when it ruled that the KOENIGs needed to establish a special relationship between Bonnie and defendant Donald London. This ruling violated South Dakota law because when a plaintiff alleges that a defendant engaged in affirmative conduct that caused the plaintiff's foreseeable harm, no such special relationship is required. Second, the trial court erred when it construed the facts in favor of Bonnie, the moving party, and against the KOENIGs, the non-moving party, when it viewed Donald's armed confrontation with law enforcement the day before Trooper KOENIG's shooting in favor of Bonnie. And third, the trial court erred when it ruled that Bonnie did not voluntarily undertake a duty to supervise her son, Donald. Now, this case arises from Donald's shooting of 30-year veteran trooper John KOENIG. This shooting was part of an escalating pattern of violence that began 2 days earlier when Donald attempted to pick a fight with two men at a local bar, and then the very next day was in an armed standoff with law enforcement that involved guns drawn. What makes this case unique is that Donald suffers from paranoid schizophrenia and as a result has delusions about law enforcement. Specifically, that law enforcement is out to get him and that they are holding his now deceased wife Ruth captive. It is these facts that were known by Bonnie, and it's these facts that form the basis for the KOENIG's negligence claim and negligent supervision claim. As to the first issue, the special relationship requirement, the defendant misconstrued the KOENIG's negligence claim, and the trial court relied on this misconstruction. Specifically, the defendant has argued that this case involves a failure to prevent a third party's misconduct. That's not what this case is about. Bonnie cannot rewrite the KOENIG's negligence claim to something that she would rather argue against. Instead, the KOENIGs seek to hold Bonnie accountable for her own actions. Bonnie engaged in affirmative conduct and therefore had a duty to exercise reasonable care. An illustration of this distinction between the distinction between preventing a third party's misconduct and being held accountable for your own affirmative conduct was illustrated in one of the cases we cited, Lepke versus Segura. In that case, the defendants had jump-started a car for a driver who was obviously intoxicated. That drunk driver was then in a car accident with the plaintiff. The Lepke court explained that the defendants' liability stemmed from their affirmative conduct, and because the defendants engaged in affirmative conduct, they had a duty to exercise reasonable care with their actions. Applying that reasoning here, the KOENIGs are alleging that Bonnie jump-started Donald's violent behavior when she lied to Donald and told him that the ATF was coming to the place he was staying. Bonnie knew that was not true, and that is the basis for the KOENIG's claims against Bonnie.
Mr. Fick, I understand your argument. I understand that you are seeking to characterize the argument or the theory as something other than responsibility for a third party's actions, but nevertheless, the third party, Donald, did act. So in some ways, it seems, not too much of a stretch to consider that to be the action of a third party, which ultimately, unfortunately, hurt and injured Trooper KOENIG. Can you help me reconcile that?
Yes,
understand that?
Yes, Your Honor. And I think the difference comes in the fact that for example, in the cases that the trial court cited, those all involved a failure to act or failure to provide some type of safety mechanism that would have prevented the attack. Here we're saying that Bonnie caused the attack, and this is consistent with the restatement second, section 302B, in that it was foreseeable that Bonnie's actions would combine with a third party's misconduct to cause a harm. And because it was foreseeable that there would be a requirement that she act with reasonable care.
Mr. Pink, doesn't the Curlin case involve some affirmative facts by the employer in that case where the special relationship test was employed? How do you distinguish that one?
Yes, Your Honor. Regarding Curlin, it's unique in the fact that it is an employment context and it doesn't translate perfectly with this case. But what I would say is that there were two analyses that this court did in Curlin. The first looked at the duty to control, and in that analysis it looked at whether or not there was a special relationship and whether or not the injuries were foreseeable. The court then went on to do an analysis based on the defendant's own primary conduct. And in that analysis, there is a question about whether or not there is some type of special relationship between the two entities. That's just not part of the analysis for the general negligence claim.
Mr. Pick, I follow up on that a little bit. Isn't the real distinction, though, in these cases in terms of the requirement for a special relationship, that the difference between intentional conduct versus negligence? So, you know, the Lepke case you cited, that's a negligence case where the third party negligently drove and hit somebody. Do you have a case where there's intentional conduct and there's affirmative conduct that causes that intentional conduct that says you don't need a special relationship?
Your Honor, the closest I believe we would come would be Lepke versus Segura, which involved the drunk driving incident. And then just to note that the underlying basis or the underlying argument that this was the product of an intentional conduct is still a fact question in this case. As we raised in our reply brief, it's still a dispute whether or not the conduct was intentional or reckless, potentially even negligent, in that the shooting occurred through a shed and that it wasn't an incident where Donald was directly pointing a firearm at Trooper KOENIG.
Can shooting where people are around, can that ever be a negligent action versus intentional?
Probably not, Your Honor. That's correct. But I would say that it would be a fact question as to intentional versus reckless. And it would be the same type of recklessness as driving a car while intoxicated, in that there is no guarantee that there will be harm, but it is foreseeable that a harm would occur. And this is consistent with the South Dakota law in that Thompson versus Summers. This court explained that it's foreseeability of an injury to another, not the relationship with another that is the prerequisite for establishing duty. This was reaffirmed in Zerfas versus Amco Insurance Company, where this court explained that the existence, scope, and range of a duty is contingent on the foreseeability of the harm.
If we overlook forgive me, Mr. Pick, for interrupting you, but if we overlook the requirement to have some sort of a special relationship, and we evaluate this strictly in terms of, as you suggest, of foreseeability, or at least that's what I hear your argument to be, what distinguishes that test, a legal test, by the way, that a court decides on its own, from the question of causation or breach, which also has a component, as you know, of foreseeability? How are they different? And how would your rule not wind up preempting questions that are ordinarily reserved on the other elements of the tort claim for the jury?
If I understand your question correctly, Your Honor, I believe that what we're arguing for is the foreseeability test of duty to be applied. And
that would be, forgive me, but that would be a question that typically our cases indicate or is determined by a court. So if a court were to determine that something was foreseeable, what impact would that have on the rest of the case, which in the other elements of the tort claim also involve foreseeability? Would that preempt it? Would that control it? Would that drive it? Would that make the case basically over?
If the court found that there was foreseeability as to duty?
Yes.
Oh, yes, Your Honor. I believe that those two test would be different. The foreseeability as to duty, it's my understanding, relates only to the foreseeability at the time of the negligent act. Whereas, for example, the causation analysis, we would be able to look at the injury itself and then look at whether or not the injury was foreseeable.
I've read those distinctions as well. How do they operate and animate to make a practical difference in a particular case? This one, for instance.
I think that there are potentially facts that could come into play in between when the negligent act occurred and then when the harm occurred that could strengthen a foreseeability analysis in terms of causation. And I think once you get to causation, you get the benefit of that. But once you're working in the duty analysis, anything that happens after the negligent act is cut off in terms of what you can argue as what makes the injury foreseeable. And I think the issue here is that where this case went off track is that the trial court did view this as a case involving having to stop a third party's misconduct. And I think that's clear in the court's case cites, specifically Small versus McKinnon Hospital, EP versus Riley, Walther versus KPAK, Meadowlands, all involving allegations that the defendants should have done something to stop the third party from acting. Whereas this case, we're saying that you shouldn't cause the third party to engage in the violent behavior or harmful conduct to begin with.
So you're saying that you may not have a duty to affirmatively halt somebody's misdeeds, but you do have an affirmative duty not to cause them by the statements here.
Yes, Your Honor. That's exactly right. And going back to kind of Lepke, it's this idea that you shouldn't jumpstart the car for someone who's obviously intoxicated, and because you're doing some type of affirmative act that's going to cause harmful conduct, you can be responsible for those acts. Regarding the second issue, the foreseeability of Donald's violent behavior, this is governed by the totality of the circumstances test.
Can I back up one more?
Oh, yes, of course.
AP Riley and the other cases that you cited, I'm thinking about all of them as we're talking. They had a component of a special relationship. Section 319 of the restatement was the issue, was the section that was discussed in EP Riley. Others, of course, Curlin was the employer-employee. And so by citing those cases and by relying upon those cases, is that consistent with your view that, no relationship is required? It seems like our cases oftentimes do, but I don't know what your thoughts are on that.
Yes, Your Honor. We would say that those cases, they all do require the special relationship, but we would say that those cases also involved a defendant failing to act, not causing the misconduct. For example, in EP versus Riley, for example, no one is asserting that the foster parents engaged in some type of affirmative act that caused the assault, or in Small versus McKinnon Hospital, no one's suggesting that the hospital itself engaged in conduct that would prompt the criminal in that case to conduct the assault. Whereas here, we have Bonnie's affirmative actions of telling Donald that the ATF was coming to the farm when that wasn't true, and she knew that that would set him off, and it did.
What was the failure to act in Curlin?
Sure. So under the duty to control in Curlin, it was the idea that they failed to control their employee in preventing the assault.
Can you be more specific? Failed to control in what manner?
Sure. They sent him to a work site where a competitor was working and a fight broke out. The allegation was that they failed to control him and that essentially was respondeat superior, that his actions were attributed.
Isn't
the
sending to a work site where you knew there would likely be a confrontation, how is that different than the alleged statement by Bonnie London here with regard to the ATF is coming?
Yes, Your Honor. And again, I would go back to that distinction that the court drew in Curlin between its two analyses, the first being the duty to control, and then the second being the general negligence of the employer, and that in the general negligence of the employer category, there was no requirement of a special relationship.
Could you characterize Bonnie's conduct as the failure to, or not refraining from saying things to her son that would prompt him to take dangerous action?
Sure. And
she didn't refrain. Is it, in the end, some semantics? more so than substance.
I would say that it's not an issue of semantics, Your Honor, because again, we're saying that she engaged in affirmative conduct. For example, if we said that Donald was going to potentially act violently regardless of Bonnie's conduct, and then that she failed to potentially tell him to take his medication or tell him that he needed to have an involuntary mental health hold placed on him, that probably would not be an element that probably would not meet the standard for negligence, and that she failed to act or failed to intervene. But what we're saying is that when she said something that was going to make him become violent, that she had a duty not to do that. And that's consistent with some of the examples we cited in our brief. The idea that you have one of your friends has a dog that will attack on a specific command, and you say the command. The idea is that you would be responsible for saying that command. Or, for example, the other example we used, a situation where you have a boyfriend and a girlfriend. Girlfriend knows that boyfriend becomes jealous, and girlfriend falsely tells boyfriend that a third party was flirting with her, and as a result, boyfriend attacks the third party. What we're saying is that in those circumstances, and in this circumstance, when you engage in affirmative conduct that cause someone else to become violent, that you can be responsible for that conduct.
But the hypotheticals you gave are a little bit different, because you have, in the hypotheticals you're talking about, you have some affirmative conduct, and then you have direct action as a result of that. Here, your affirmative conduct, I think, maybe happened the day before, or at least some period of time before. You have her saying ATF's coming. He doesn't go out and go hunt down the law enforcement. Instead, it's when law enforcement come that the violence breaks out. So, which, whether he perceived that as ATF or, I realize those are fact issues, but that's a little different scenario than the hypotheticals you're presenting.
And just to clarify, Your Honor, the record indicates that the comment was made around noon, and then Donald immediately became upset and then went and retrieved firearms and then came back to the house. So, we're saying that he engaged in a pattern of violent conduct that began instantaneously after the call. And
Noon on the
ongoing.
7th of January.
On the 7th. Yes, Your Honor. Sorry, the statement was made January 7th around noon, and then the resulting conduct, and then the shooting actually occurred around 4 p.m. that same day. And again, we would be saying that this was a pattern of behavior that was just continuous. Regarding the second issue, the foreseeability of Donald's violence. Under the totality of the circumstances test, Donald's behavior was foreseeable. Potentially analogous case here is Small versus McKinnon Hospital. In Small, what happened was there was an assault on someone who was using a parking ramp of the McKinnon Hospital. The person was abducted, she had been raped and was murdered. This court held that that the assault and resulting actions were foreseeable, specifically noting that the condition of the parking lot enabled the assault, the bad lighting, that the hospital knew that people had partied there and had gotten drunk there. In fact, the hospital itself had conducted rape awareness seminars in order to warn hospital employees that there would be a danger in the parking lot. Despite the fact of no previous violent encounters, this court explained that the assault was still foreseeable. Much like Small, this case has a number of similar characteristics in the facts that Bonnie knew about Donald and the situation. For example, Bonnie knew that Donald was a paranoid schizophrenic who suffered from PTSD and had delusional beliefs that the police had taken his wife hostage, that the police were after him, and Bonnie knew that if Donald saw the police, he would hit an, quote, insanity point.
2 minutes, counsel.
And go delusional. These delusions often involved Donald blacking out, becoming angry, potentially getting in fights, and he couldn't separate reality from fantasy during these delusions. Bonnie also knew about the situation, that Donald was off his medication, that the morning of the shooting, when she talked with him, he was spiraling out of control, and that he had repeatedly called her prior days crying and inconsolable, along with the fact that Donald had been in an escalating pattern of violence. Bonnie knew that Donald believed that the ATF had his wife captive, and she told him that they were coming for him. Donald's violence in this case was foreseeable because Bonnie knew that this would set him off. And lastly, regarding the third issue, negligent supervision. Under these circumstances, we assert that Bonnie undertook a duty to supervise Donald when she started dictating the terms of his medical care, and in the fact that she had him return to the farmhouse even though he hadn't been committed and had been in an armed standoff with law enforcement just hours before.
Earlier in the complaint, there was a negligent entrustment argument, firearms, alcohol, that sort of thing. I didn't see that as much in the appellate submissions. Am I right in thinking that you're no longer pursuing that?
That is correct, Your Honor.
Thank you.
The law compels that the Koenigs have their day in court. Trooper John Koenig was shot in the line of duty because of Bonnie's actions. But for Bonnie's conduct, telling Donald that the ATF was coming, knowing that he had these delusional beliefs about law enforcement, Trooper Koenig would not have been shot. For these reasons, the Koenigs respectfully request that this court reverse the trial court's summary judgment rulings.
Thank you, Mr. Fick. Mr. Fox, you have 20 minutes, sir.
Chief Justice, Justices, Counsel. May it please the Court. I am Aaron Fox. I'm from Sioux Falls. Mr. Travis and myself represent Bonnie London, the appellee in this matter. We ask this Court to uphold the trial court's decision when it applied this Court's two-part test of control and foreseeability to the element of duty to appellant's general negligence claim in a third-party action. The appellants do not dispute the validity of this two-part test. They merely dispute its application to the present matter. They ask this Court for an exception to the two-part test, eliminating the element of duty, of control within duty when an individual engages in an affirmative act. To permit this exception would create unreliable, inconsistent, and unjust results. This Court first applied the two-part test of control and foreseeability within the element of duty back in 1989 in Small v. McKinnon, known as Small 2. This Court continued to apply this two-part test throughout the years in 4 opinions. And those opinions stand for the proposition that an individual has a duty to another when that individual has control of the environment or the third party and the harm is foreseeable.
Mr. Fick argues this isn't a duty to control the third-party case at all. And he, if I understand his argument correctly, he takes on that issue right at the outset. So to that argument, and if he's right, he hopes to navigate around all those cases and 315 of the pre-statement and all those rules. To that argument, what do you say, Mr. Fox?
Thank you, Justice Salter. What I say is what we're focusing on is Bonnie's conduct, and that's not what the focus is. The focus is on the unlawful conduct of the third party, and that's what dictates what test is applied. This Court has looked at fact scenarios, and within the fact scenarios often dictate what test is applied. For example, in Summers, they said there was no relationship required, it was this foreseeability. But in Johnson v. Heyman, the Court said, where there was the engineer's report, that the homeowners eventually sued the engineers saying, this thing was inadequate. What you did was inadequate. And the Court said foreseeability or the relationship could be the test in that case. Here, when you have an intentional, unlawful conduct by a third party, this Court has consistently applied the two-part test. And that's what Small 2, Walters, EP, and Curlin all stand for. And this Court applied the two-part test even when there's this allegation that the individual, not the third party, engaged in an affirmative act. In Curlin, the employer engaged in an affirmative act and assigned an employee to a work area knowing there was going to be a competitor, knowing it was likely to be a confrontation. And that individual engaged in intentional unlawful conduct, which dictates the two-part test. And And of course, to do otherwise would create these inconsistent, unreliable, and unjust results. For example, justices, what happens if you have an individual who engages in an affirmative act and an omission that results in a third party intentionally inflicting harm on another? You have these two acts now, and they equally contribute to the third party's conduct. What test is applied? And who decides? Do plaintiffs get to assert the affirmative act so that they get the more lenient test? And we don't have to look very far for an example. We can look at the present case. It's alleged that Bonnie engaged in an affirmative act, which we dispute and which is relied on despite double hearsay. But they rely on I lost my train of thought, excuse me. Okay, so you have these unjust results. So you have this individual that engages in the affirmative act and the omission. So who gets to dictate the test? Is it the plaintiffs? Do the court decide? Do the defendants have a say? And they equally contribute. Or what happens when you have an individual who engages in an affirmative act and an individual who engages in an omission that equally contribute to a third party intentionally inflicting harm on another? I think
Mr. Fox, can you respond to Mr. Fick's comment on the Lepke case where individuals jumpstart the drunk driver's car and he drives and kills somebody? Reckless conduct, arguably. He argues same situation here. Bonnie jumpstarted essentially her son. He goes out and starts shooting. Fact question as to whether it's reckless conduct. Is there a distinction here?
Absolutely.
What is that?
Justice Jets. First, we're focusing again on Bonnie's conduct. The third-party conduct is what dictates the test, the intentional unlawful conduct. Lepke was not intentional unlawful conduct. That's what dictates the test.
Mr. Fick says it's reckless, and there's a distinction, he says, between intentional and reckless conduct. Do you
Well, I think I'm sorry, what Mr. Fink's getting at is that Donald's conduct was similarly reckless. Donald walked outside the farmhouse and said, I'm going to die today, you're going to die today, and fired 146 rounds directed at law enforcement, most certain to result in harm towards law enforcement. That's intentional conduct. Now, in Lepke, the individual gets in his car, and he does not intend to drive or hit somebody. That was negligent conduct. And I would emphasize that Lepke, courts had viewed Lepke as an agency case. Other courts had looked at this case because they applied the two-part test and they tried to reconcile this Lepke case. And in that case, one of the defendants was a bar owner who refused to serve alcohol to the intoxicated individual, but at the same time directed his employee to jumpstart the intoxicated individual's vehicle. Thus, control over the employee and foreseeability of the harm. But again, I would point out that Lepke does not stand for intentional unlawful conduct, which we're dealing with here. Furthermore, Lepke is a 1981 opinion from Colorado. This court has consistently applied the two-part test in intentional unlawful conduct, which is most certain what Donald engaged in. And I would like to go back to the issues that are created if you depart from this test. I think appellants are of the position that an affirmative act creates this risk. And when there's this omission, the risk is no more, and it's this failure to prevent. That's incorrect, justices. Omissions create just as much risk, if not more at times, than affirmative acts. And we don't have to look very far for an example. We can go to small 2, the McKinnon case. And we look at what McKinnon knew, and we look at what McKinnon did. McKinnon knew that 30% of all rapes took place on parking ramps. McKinnon knew that there was a parking ramp racist in the community. McKinnon knew that, quote unquote, we have been lucky so far. McKinnon knew the lighting was poor. McKinnon knew that its security agents had confronted them about addressing the inadequacies, and what McKinnon did was they eliminated more security. Then McKinnon goes over and tells its staff, This parking ramp, it's insufficient. It's dangerous. But yet they did nothing to address the danger and the risk that they created through their very omissions. And the two-part test applied. And if the two-part test is going to apply in McKinnon when you create an environment, you're most certainly going to apply the two-part test when an individual merely makes a statement that may incite someone that is relied upon at this point as double hearsay. So it's only just to apply the two-part test when an individual even engages in an affirmative act. What appellants are really arguing, Justices, is that Bonnie failed to govern her own conduct. Not that she didn't prevent Donald, she failed to govern her own conduct. Now, to create an exception for failure to govern your own conduct would swallow the rule that generally people are not held liable for the intentional unlawful conduct of another. And a failure to govern your own conduct was addressed in McKinnon again. It's alleged that they didn't have any control over the third party, but that they failed to govern their own conduct. And the two-part test applied. And rightfully so, because to do otherwise creates in these inconsistent, unreliable, and unjust results. And what we'd have is the rule or the exception swallowing the rule, and you'd have a handful of litigants that have little to no contact and no control over the unlawful conduct of another. And we could look at our present case. All right, we look at who was involved and who made decisions, who may have failed to govern their own conduct. Oh, there's Mike, there's Bonnie, and there's law enforcement, and there's Dakota Counseling, and there's the Chamberlain Mental Health Board, because they all knew what was going on. They all knew that Donald was struggling with his mental health, and they all engaged in some act. Most notably, the entities released Donald. And they all have one thing in common, Justices. None of them controlled Donald and his intentional and lawful conduct. So to depart from this good rule that this court has consistently applied would permit litigation against others that don't have contact and don't have control over another.
It was Bonnie's house?
No, it was her grandmother's house.
So did she have a possessory right in the house?
No, she did not.
Would that have made a difference?
I think that could make a difference if she permit Donald to stay at the house, if she possessed it, and she had some ownership, and she knew that there were guns there, and she let Donald stay there knowing he had these issues of, there could be a negligent entrustment, but that's not what we're dealing with. She had no ownership interest, there were no guns when the alleged statement was made, and Bonnie didn't let Donald stay there, so.
Just a slight little deviation here. Did the trial court address the double hearsay argument?
The trial court did address the hearsay arguments, and I would just explain how the statement came about. I think that helps establish why this two-part rule is important. The statement came about when it's alleged that Bonnie called Donald, and Donald's on the phone with Bonnie, and Mike's in the room, but not indicating that he's nearby or anything, and not indicating the phone's on speaker or anything. He claims that he heard Bonnie tell Donald on the phone that the ATF was coming to look around. And then Mike reported that information to Sheriff Miller, and it was these exception applied in that opposing party statement for hearsay 1 and excited utterance hearsay 2. But
Mike is now deceased, so it would have to come in through the officer.
Correct. And I think that demonstrates the importance of why we have this two-part rule, because now we're going to have liability potentially imposed upon someone for a statement that, frankly, we contest was ever made, and the way and manner it came about is subject.
I guess my question, did the trial court address whether that was admissible evidence and if it's not before the court now, that's what I'm trying to determine.
For the purposes of summary judgment, it was correct. It was admissible for purposes of addressing summary judgment, but it did not address it for the purposes of trial. Okay. That was left.
Thank you.
What I'd like to do is go into control and talk about whether Bonnie had control, because the two-part test applies, and it it should continue to apply, and if we don't apply it, it creates all these issues. So did Bonnie have control over Donald? Well, this court addressed control in small one, where the parolee on maximum supervision kidnapped, raped, and murdered a young woman. And that woman's husband sued the parole agent. And this court analyzed whether the parole agent had sufficient control over the parolee. And this court analyzed that, yes, there was this legal supervision, and yes, the parole agent was to check on the parolee and make certain he had his employment and do these updates, and the parolee was to report to the parole agent. But it was determined that the parolee conducted his own day-to-day affairs and made his own day-to-day decisions. Here, Bonnie didn't have any legal authority over Donald, and there's no indication, and there's nothing to support that Bonnie had to report information to Bonnie. And furthermore, Donald made his own day-to-day decisions. He decided to come back to South Dakota. He decided where he was going to live. He decided to drink alcohol knowing he has mental health issues. And on the January 7th, he made the decision to get the guns, threaten law enforcement, and shoot at law enforcement. Bonnie didn't make these decisions, and she didn't help him make these decisions. Furthermore, law enforcement had Donald twice and released him both times to his father, Mike. And Mike was with Donald this entire time, assisting Donald and helping him and just helping him through these times. Bonnie was around for 1 hour through these 3 days. And appellants don't argue that Bonnie had control. In fact, that's why they seek the one-part test, because they know Bonnie didn't have control over Donald. Simply put, Bonnie did not control Donald, and they cannot satisfy that element. There comes this question of foreseeability. Was it foreseeable that making this statement would harm law enforcement? And when we look at foreseeability, we look at all of the facts. And as appellants recognize, yes, Bonnie knew that Donald had mental health. She knew that he had delusions about law enforcement. She knew that if the ATF was coming, if Donald knew the ATF was coming, he would likely become upset. But what else did Bonnie know? Bonnie knows that on January 6th, law enforcement came to the house. They went in the house, pointed a service weapon at Donald. Donald had a weapon, and that confrontation ended with Mike, Don's dad, Don, and Sheriff Miller sitting around a table talking about Donald's mental health and how to address it and what the next step should be. And what else does Bonnie know? Bonnie knows that law enforcement confiscated weapons. They took the remaining weapons, they put them in a safe, and they gave the key to Mike. And then Mike transported the guns 5 miles to Kimball. So on January 7th, when Bonnie made this alleged statement about the ATF, Bonnie knows that Don is calm. He's not threatening law enforcement. Law enforcement's not at the house. There's no indication law enforcement's going to show up at the house. She knows that law enforcement was at the house the prior day, pointed a gun at Donald. Donald had a gun. It ended peacefully. And she knows that there are no guns at the farmhouse. So while it's likely Donald would become upset if the statement was made, Bonnie couldn't reasonably anticipate that Donald would become so upset that he'd get in the car, he'd drive 5 miles, he'd get the guns, he'd drive back 5 miles, he'd get on the phone, he'd call law enforcement, tell law enforcement, I'm going to shoot law enforcement today, especially when he's never threatened law enforcement like that, and he's never shot or fired at anyone in the past.
2 minutes, counsel.
Thank you. That he would go outside with his rifle. Law enforcement would show up at the house, not as they did the day prior, where they show up in the driveway, they surround the house. Donald's out there with a rifle, law enforcement points their gun at him, Donald drops it, goes in the house, comes back out, gets in his truck, drives up, gets the gun, backs back up towards the house, now pointing his rifle towards law enforcement. Mike comes outside, his father, a prior law enforcement officer, an individual who had tried to calm Don the previous 2 days, now comes outside and says, shoot those SOBs, pointing in the direction of those he worked with and his friends, and then Mike saying, I'm going to die today, you're going to die today, followed by 146 rounds. While it's likely Donald would have became upset about the statement, Bonnie could not reasonably anticipate that sequence of events taking place, especially when Donald has never fired a gun at anyone, including law enforcement.
Should that determination be made by a jury?
Not when we're addressing the element of duty, Justice. That would be a determination for this court to decide. When we get to causation, but yes, but not at this instance. We're talking about duty. This case really is about a mother who loves her son, and her son has mental illnesses, and she tries to help him and does the best she can. But her love and attempts to help her son, Justices, must not be mistaken for control. We must remember that Donald acquired the guns, Donald made the threats, and most importantly, Donald fired 146 rounds at law enforcement. Donald's responsible for his conduct, not Bonnie. We ask this court to apply the two-part test that it has consistently applied in third-party actions regarding intentional infliction of harm. It's good law, and to depart from it would create these inconsistent, unreliable, and unjust results.
Thank you, counsel.
Thank you.
Time has expired. Mr. Fick, you have 10 minutes, sir, for rebuttal.
Yes, sir.
May it please the court. The KOENIGs are seeking to hold Bonnie accountable for her affirmative conduct. And that's exactly what we're saying, is that you don't look at the third party's conduct, you look at Bonnie's conduct. And the fact that but for Bonnie's conduct, this shooting would have never happened. Bonnie knew that Donald was in an escalating pattern of violence. She knew that he had just been in an armed standoff with law enforcement. And despite knowing all of these facts, she falsely told him that the ATF was coming to where the place he was living, his home.
Mr. Fick, your arguments a few moments ago, and I don't want to parse your words, but something you said was a thought that I'd had earlier. This notion of having a but-for cause test, does that and can that reliably be used? And if I'm taking out of context or you didn't mean it that way, I'm happy to listen to your argument. Would that be a basis to impose a duty? Just this notion that, hey, if she would have done things better, if there would have been a more optimal, whatever way for her to intervene, this wouldn't have happened. That doesn't seem like a way to base a duty determination.
Yes, Your Honor, and I think that's exactly right. The but-for is more in terms of saying that this was foreseeable in the context of duty, and I don't necessarily mean that.
No, I understand that, but as long as I've interrupted you, let me ask you this. So why wouldn't your affirmative duty argument or theory work still within our cases in the restatement sections that generally apply this two-party test? And the reason I ask that is, doesn't there have to be some sort of a relationship, special, whatever you want to call it, but doesn't there have to be some sort of a relationship in order to have the ultimate result or the range of possible results be reasonably foreseeable? In other words, if somebody goes up and does something affirmative to somebody, they have no idea who they are, they have no relationship with them whatsoever, you could make an argument that it's not reasonably foreseeable that they'll do anything, good, bad, or indifferent. But if you have a relationship with that person that instead informs your assessment of foreseeability, doesn't there have to be some sort of a consideration of what kind of relationship that is? Otherwise, you can't really determine whether it was reasonably foreseeable or not.
And I think that is exactly right.
Question mark.
I think that's exactly right, Justice Salter. But I think what we get to is the fact that the foreseeability would limit the duty here, and that foreseeability would, for example, if I went up to someone and said that the ATF was coming for them, I would have no reason to know that that would spark them off into a violent rampage. The difference here is that Bonnie did know that.
Because of a relationship.
Yes, Your Honor. I mean, I would say that even if...
your argument.
Yes, and even if they weren't mother-son, if they were some other type of incidental relationship, that knowledge through the relationship, yes, would be attributable to that person and therefore
Circle back to the outset of your remarks here today. which is an effort to, not critical in any way, but an effort to distinguish this case from the standard cases involving third-party conduct, is that defensible? If at some level there has to be some idea of what that relationship was, and maybe you can talk around the edges of whether this was special or special enough or whatever, but it can't just exist without some sort of consideration of the relationship in some way. Would you agree with that?
I would say that there has to be some type of foreseeability, Your Honor, and that generally probably would be through a relationship. I realize negligent entrustment is like slightly different, but when, in terms of like holding someone responsible for criminal conduct that results because of like your actions, we're not necessarily looking at a special relationship in that case. It's the idea that you've done something that makes it viable for another party to like cause harm to another.
What rule did the Intermediate Court of Appeals in Colorado apply in Lepke? What rule do you get from that? Where did they go for that determination? There's a 1980 case called Krulik, or something with a K, Krulik, I think. But does that really support their affirmative conduct distinction?
So as far as the case that we cited regarding the drunk driving, yes, it does, because they said that it's the affirmative conduct that forms the basis of the liability. It was a relatively short opinion, Your Honor, but yes, that's exactly what they held. And I would say that to some extent...
They held, but what was their rule? Where'd they go for that rule?
Sure, I can...
No, that's okay.
Okay.
I was just curious.
They cited the restatement second, I believe...
320, which is the duty to control somebody and take over supervision of them.
Yes, Your Honor, and I do
That's
agree...
not this case.
And I don't think it was in that case either, quite frankly, Your Honor.
Exactly that case.
Yes, I don't disagree that that's what they cited to. I don't think that was maybe the best legal cite. I don't know if that was the factual basis for the case, but just the general proposition that affirmative conduct can cause the basis for...
Yeah. Okay.
And the only other thing is, when I looked at the citation, I don't know if what they were saying in the parentheses cite for Lepke and then what the section actually stated, I don't know if that was intentionally citing to that section or if like there seemed to be I will admit,
I understand.
distinction between those two things.
Good enough. Thank you.
And regarding the Curlin case, I would just highlight that when the court was talking about the duty to control, it specifically engaged in an analysis that looked at the special relationship and then looked at foreseeability. And then the court went on to explain the distinction between the duty to control and the general negligence claim being brought against the employer. And the court explained that Curlin asserts that PKJ had a general duty of care when carrying out its business, and that this argument to a great extent overlaps with Curlin's duty of control claim. However, there is a subtle difference between these two. The duty of control concerns PKJ's handling of its special relationship with Halverson. The general duty, the general negligence duty, concerns PKJ's duty to conduct itself reasonably. And it's like that distinction that we are applying here, that we're not looking at whether or not Bonnie had sufficient control over Donald, at least in terms of the negligence claim. It's the fact that she engaged in affirmative conduct that caused his violent behavior. And again, Your Honor, this is not a situation where a parent was placed in an impossible situation or an impossible choice. Bonnie also has antipathy towards law enforcement. And this idea that she just didn't need to say that law enforcement was coming for Donald when she knew that that was the attack word would set him off is the basis for her liability. And lastly, the defense would argue that Donald's misconduct and Donald's criminal behavior is the matter before this court and that Donald is solely responsible. But that does not diminish Bonnie's responsibility when she engages in affirmative conduct that causes Donald to become violent. Bonnie should have foreseen the incident that occurred before. She knew the day before the shooting that if law enforcement showed up, that there would be a volatile situation. She told that to law enforcement before they even arrived on January 6th. Then we have an armed standoff. Knowing this information on January 7th, she falsely tells him that the ATF is coming for him. And it results in another armed standoff with shots fired. Because of this incident was foreseeable, and that Bonnie lit the fuse to a bomb that she knew was going to explode, this is the basis for the KOENIG's claims. Therefore, the KOENIG's would respectfully request that this court reverse the trial court's summary judgment rulings in favor of Bonnie and reinstate the KOENIG's negligence and negligent supervision claims.
Thank you, counsel. The court will be in recess until 9 o'clock tomorrow morning.